Welcome, all of you mere mortals, you small peons of the world that have been absolutely gifted with the incredible experience of being able to watch the Honorable Sarah Boone in court. She is so fun to watch. Well, maybe I should say that more accurately. She's kind of that person that we have fun disliking, right? So, yes, today there is quite a lot of chatter and discussion about one Sarah Boone and how she is really blossoming in this new role that she's in. She looked dashing in her street clothes, I should say, probably the best we've seen her look. And she now carries herself with such a regal air. It's almost as if Sarah thinks that she is running for president. So, we're going to watch today's hearings, and I have not watched them. I peeked in and I chuckled to myself, and I said, this is going to be a very fun um, trial. And so you can see on her podium, she definitely has her juice bottle. She's got some orange juice. She's got her little hot dog. She did spill her chips, unfortunately. And she's a little messy with the mustard and the ketchup. But hey, this is a very talented and special woman. And now we are going to watch her hearing today. Let's see. And I am trying, I think I've got the wrong layout. I do. I'm going to have to change my layout here. There we go. Okay. I'm streaming off the Crime Talks video. So, hey, Teresa Walton, wonderful to see you. Thank you for being here. So, we're going to stream off of Mr. Scott Reich Esquire's channel, and we're going to watch this hearing and see how it goes. All right. So if you've already seen it, forgive me. I worked all day. I literally just finished about 30 minutes ago. So, so I'm going to go ahead and just watch it. I hope you guys will join me. I'm going to stop and comment, as I often do as I go through these reaction videos. My understanding is that there is, in fact, a jury seated, which is wonderful. And tomorrow, we will get opening statements with the Honorable Sarah Boone. And take a good long look at, Owens. He looks furious, doesn't he? And this was simply swearing her in. Like, this was not anything. I kind of think that Owens is having an existential crisis, like, oh my God, what was I thinking? But nevertheless, here he is. He is going to show us what a professional he is. He's going to stick it out, and he is going to get Sarah through this trial come hell or high water.
Ma'am, good morning. Can you state your full name and date of birth for the record for me? All right, Ms. Boone is seated at counsel's table wearing a dark gray suit and a yellow blouse.
And she is feeling sassy, all right? She knows that she is looking good. She has figured out the jailhouse eyeliner. I think she's got a little bit of makeup on. I really do. And she's just so pleased with herself. She is struggling to keep that smile off her face. I think it's kind of amusing. Mr. Owens, he's not so amused.
She is in custody. However, she is not being shackled for the purposes of the trial based on the court's prior findings. We're here to conclude the objections as identified in the state's response to defendant's fifth amended reciprocal discovery exhibit list. Court has reviewed the objections and the defendant's fifth amended reciprocal discovery exhibit list. Anything else we need to address, State, before we begin?
One thing I did happen to notice as I peeked in a couple of times today, it appears, at least the little bit that I watched, it appears that Sarah is only talking with this attorney, and I apologize. Is his name Cunningham? I'm not sure what his name is. I'll figure that out. But she seems to only really be talking with him and this young woman behind her. Owens almost seems like he's cut off contact with her. I think that there's trouble in paradise already.
And addressing those objections.
Judge, I do not see a written order from yesterday's website.
Nancy,
I want to make sure I am crystal clear.
it epitomizes something, my friend. And welcome. It's really great to see you.
Statements by either party and so on and so forth, so that I am not in violation of any motions of the main case law.
Try to do something with the sound.
What I can say or not say.
Okay. Madam Clerk. Were you anticipating a written order on the motions in limine?
I felt like I heard you say everything that I anticipated was going to be put out, at least on court minutes by the clerk's office. I wasn't anticipating type of written.
Okay, that's what I wanted clarification on. Thank you.
But I just do want crystal clear clarification as to what we are both doing. Based on that, I have some things that I would like to get on the record for post-conviction matters.
Sure. All right. Madam Clerk is pulling up the file now, sir. Give us a moment.
And this live stream lasted about 2 hours and 47 minutes.
You did not.
There may be some, yeah, it does look like there's some downside time in there.
Madam Clerk is advised that court minutes were not prepared for the ruling from yesterday due to it taking place during the trial and jury selection. So digital was not providing recording services yesterday. So it would have been Madam Court Reporter. So I would have to beg and plead if she's able to get me a copy of what it was so that it can be re-reviewed so that we're all on the same page for that.
Thank you.
Madam Court Reporter, how long do you think that would take you? Is that acceptable? Can we address it at 1:30 before we
Makes it very difficult to prepare for opening statements when you don't know what I can say.
No, I agree with you, and I'm not trying to, submarine anybody or put anybody in an inappropriate box,
I
but
understand, but I need to know what I'm going to be allowed to say.
I don't disagree. But is 1:30 acceptable?
No.
Okay, well then, short of taking a break right now and having her create it, I don't know what else to tell you. State?
We have an out-of-state witness and people that are scheduled to come in. So we do see problems with that.
Okay.
Wow.
I don't know how long jury selection is going to take this morning. I can't recall off the top of my head how much time the state said, or the defense said they were going to need for the purposes of their questioning. So, Mr. Henderson, how much time do you think you're going to need, sir? Okay. Correct. That's correct. Okay. Mr. J?
I just need that ruling so that with enough time to prepare.
I understand. So the way I see it is we've got a couple of options. We can, and there's no good way to cut this up. One, we can wait on the objections, which I know you do not want to do. Or we can stop now. Madam Madam Court Reporter can provide a rough draft of what was ordered yesterday. We could go over it and review it, make sure that we're all on the same page as to what the court's ruling orally was yesterday as to the various motions in limine. Then we can continue with jury selection, or then we can pick up with the objections. I'm amenable to however it is you want to proceed. I understand.
Sir, you are the judge. Maybe you should be taking control of the situation and making some command decisions. This is not looking good, y'all.
Understand your concerns of running afoul with a motion in limine. I totally understand that, but it will take her some time to prepare this.
I'm fine with either letting her do that now or letting her do that after we argue this hopefully last pending motion in limine, but prior to getting into jury selection so that I have time to rework what my opening statement will be based on the ruling during Mr. Henderson's voir dire.
Let me then ask this question. Assuming we get a jury this afternoon, what are the concerns with starting tomorrow morning with openings? Is it due to out-of-state witnesses that may be unavailable or because of their schedules?
I feel like if we have time, we should at least get into preliminary instructions and opening statements and use every waking moment we have to not waste these jurors' time until 5 o'clock today.
I agree.
Right. Madam Court Reporter, how long do you think it would take you?
And we YouTubers, we
Is that
also
acceptable as opposed to in
not
print?
want our time wasted.
You could go back and pull back the audio from and re-review it and just.
Now this, my friends, this is not a happy couple, right? What do you think? Are we thinking that Mr. Owens is kicking himself in the proverbial behind, saying, "My God, what was I thinking?" It looks like that, doesn't it? Or he just sort of looks like, "Man, I need a drink." He looks really pretty tore up, I think. What are y'all's opinions? Yeah, this is not good. This is not good. And honestly, I probably should not be laughing, but just look how pleased she is to have all this turmoil around her. She is currently in her role as Madam President. She is feeling sassy. She knows she looks cute in her business suit. And she has got that judge jumping. And yeah, in her mind, she's having a great little fantasy. And oh yeah, there's snacks at the podium. He's just like, oh my God, my career is never going to recover. It's actually kind of tragic because he did think he was doing a good thing, right? I do feel sorry for him. He's pretty angry about the whole mess now.
Provide it to us now? Okay. All right. Then we'll take a short recess. Just let us know when you're prepared to give us that ruling. And then.
Boy, that man is furious. Watch his face.
Okay. All right. Then we'll take a short recess. Just let us know when you're prepared to give us that ruling, and then we'll go from there. Wow. Anything else we need to discuss before we take this brief recess?
Hang on.
State or Mr. Owens? How long do you think? 10, 15, 20? Okay, great. All right, we'll be in recess till 9:45. Thank you. Yes, sir. Yes, sir. Yes.
Damn, you can't hear it.
You're talking about the motion in limine regarding anticipation of affirmatively pled intent to use battered spouse syndrome evidence? Fine. Okay, well, that saves me some time then, so I appreciate that. All right, so do you have any objection then, Mr. Henderson, to the granting of the state's motion in limine, which would allow the state to be able to outline in opening statements and present evidence in the state's case in chief in anticipation of the use of the battered spouse syndrome defense at trial. All right, motion's granted. All right, we'll be in a brief recess till 9:45.
There is something is brewing between Owen and Sarah. Look at him right there.
We're off the record. Thank you.
Interesting. But she's pretending that she's an attorney. She's got her makeup on, got her hair all fluffed up. She's feeling all sassy. And finally, the camera is on her. Finally, her whole life, she's been waiting for that moment of significance. And boom, whoop, there it is. All right, so here she is. We've been through our waiting period. Let's take a look here. She says, let me get my important papers in order. I'm ready to be an assistant attorney with the Honorable James Owens. We got this, Jimmy. We are going to be victorious in our quest for justice for abused women everywhere. Go, Sarah. Go, Sarah. Who's your daddy? Who's your daddy? We're going to have a lot. What was that? What was that? Was that a grapefruit picture? Is that a coloring page of a grape? Is that a coloring page of a grapefruit? Am I crazy? Yes, don't answer that. She says, look at my picture. Did I color it? Power and control. What? What the hell? What the hell? What is that, y'all? Boone's Farm was a brand of cheap wine in the 70s. I myself fractured fairy tales. I favored tickled pink. Oh my God. Alpha to Zeta. What is that? Is that a coloring? It is. It is. It is a coloring page. And it says, okay, so this is a grapefruit right here. Okay. This up here, the words say power and control. Now, we're a pretty smart group of people in this channel, right? So let's put our thinking caps on. What do you think the purpose is of this little bit of artwork? She does look like she shows it to Owens and goes, hey, do you like my picture I made? So do you think that she drew this and colored this overnight? Like, do you think that? Let's slow it down so we can get it at the best angle and see what this is. I am intrigued. Okay, that's not very good. That is absolutely a grapefruit. There is no doubt. Maybe it's a Venn diagram. There is no doubt that is a pine. Okay, so grapefruit with power and control. Let's see what that is. No, it's a lot about, let's see if I see a coloring page or something. No. She colored that, y'all. That's her artwork. Her artwork. Oh, this is so crazy. This is so crazy. So there's a power and control wheel. And the power and control wheel embodies like physical violence, sexual violence. Could could this be, is this her cheat sheet for how being a battered spouse? I believe that's what this is. I think she's I think she's memorizing her condition. So when she gets up on the stand, she can say, "Oh, here's all my symptoms. Here's what happened to me." Yeah, I'm convinced that's what that is. The prosecutor should call that into question. Wow, this is going to get so damn weird. Okay. So at least we know now where it came from. Okay, it is funny though. I'd rather think of it that it's, her artwork. She is revising history, fractured fairy tales, but it is amusing, right? And look at the smile on her face. She's so proud. She's so pleased that she has her little look, James, and we can use this in the trial too. And James is looking at this and he's thinking, oh my God, I'm never going to work again. Oh, I got to change my timing. Hold on. All right, here we go. She's so happy. Look at her smiling. Oh, Sarah. She said, I worked so hard on that. I am feeling so good about being an assistant.
We're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. We get appearances for the state.
Oh, she is so happy to be the target of the camera. Never been happier.
Okay. Ms. Boone is seated at counsel's table wearing the same clothing from this morning. Ms. Boone, a third of your defense team is not present at the moment. Are you amenable to proceeding without Mr. Beck being here? Okay, thank you very much.
I am, Judge. We can continue.
That cures itself. Counselor? Thank you. Record reflect that Mr. Beck has just entered the courtroom. All right, courts had the opportunity to review the excerpts from the motion in limine hearing from yesterday. And my understanding is both the state and the defense were provided copies of same. Mr. J, is that accurate?
Yes, Your Honor.
Mr. Owens, is that accurate? Okay. The courts reviewed it. Are there any questions with regards to the court's rulings on that motion?
Yes, sir.
Yes, sir.
My is that based on
Oh my God.
Sure.
They are all quite testy, aren't they? They're all
Madam Clerk's providing you a printed copy, sir.
they're so cranky, except for Sarah, who is tickled to death.
Bless you. Have you had the opportunity to review that excerpt yet, Mr. Owens? All right, go ahead and take a look at it.
Oh my goodness, this is going to take a long time. Oh, look, she disagrees. She's not happy. She says, excuse me, James, in my expert opinion, as assistant attorney under your direct tutelage, my opinion is that we should object to this entire paragraph. Oh, she doesn't like him in her personal space. Did y'all see that?
Okay. All right, Mr. J, you may proceed.
Thank you, Judge. We are referring to a rough draft printout that the court reporter made. It's 4 pages of part of your rulings from, there were several motions yesterday, but in this one, it's on page 1, lines 22 through 24. Part of the court's ruling was it's indisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court prior to battered spouse syndrome evidence coming in. And perhaps the state was clear in its request, and I apologize if I was not in our motion, though, but paragraph 24 of the state's motion includes a quote from the Holland case. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. Holland versus State, 916, Southern 2nd, 750, page 760 of that opinion, a Florida Supreme Court case from 2005, which was quoting Quintana, Quintana versus State, 452, Southern 2nd, 98, page 100, a Florida first DCA case from 1984, also quoting Williams versus State, 252, Southern 2nd, 243, 246 is the page, Florida fourth DCA, 1971, Reed, REID versus State, 213, Southern 3rd, 1110 at page 1111. Florida 5th DCA 2017, Rudin versus State, 182, Southern 3rd, 724 at page 726, Florida 1st DCA 2015. So what we were asking for is in addition to the battered spouse syndrome expert testimony to not be mentioned prior to an overt act being laid was any evidence of the victim's character, including reputation or prior bad acts. We apologize if that was not clear, since the motion is titled the battered spouse syndrome evidence, but the backbone and basis of that battered spouse syndrome is obviously prior bad acts by the victim. So we are seeking a pretrial ruling as well on the admission of prior bad acts, specific bad acts, or reputation evidence of decedent.
Thank you. Response.
I just have one question as to what time. Are we talking about before dire? Are we talking about opening statement? Or what time are we talking about?
During the testimony in the trial.
That was my takeaway.
Okay. He's absolutely correct.
Okay, the motion's granted. So the court's going to rely on that specific excerpt in Holland, 916, 7 seconds, 750, at pinpoint 760 through 761.
I totally
Beginning with, as a
agree,
general
Nancy.
rule, evidence of a victim's character is inadmissible to prove actions in conformity with it on a particular occasion, section 90.4041 Florida statutes. However, when a claim of self-defense is raised, a defendant may introduce evidence of a victim's character to establish who the aggressor was, or that the defendant was apprehensive of the victim at the time of the homicide. Internal citations omitted. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an, quote, overt act by the brackets victim, end bracket, at or about the time of the bracket incident, end bracket, that reasonably indicated a need for bracket self-defense, end bracket, internal citations omitted. That's the standard. So hearing no objection from the defense, the motion will be granted. Received and understood. Any other clarifications for the purposes of opening or trial based on the court's oral rulings on the state's motions in limine yesterday?
Your Honor, and then the only other thing that beg of the clerk of the court and the court is just that we can have some written rulings, even if it's just minutes from all the motions that were ruled upon yesterday, at some point. For the record for the 60 days.
So he can do his opening statements.
Okay.
Yes, ma'am.
You really have to
All right, thank you.
appreciate
Anything
that
further
attention to detail.
from the state before we proceed with the objections? Defense. That is correct, and the court ruled specifically on that yesterday, and that's in the excerpt that was provided to you and your co-counsel. All right, thank you.
I also believe part of the court's ruling was that the testimony that was proffered, the expected testimony of the defendant that was given to the experts, I believe the court's position was, if that is the testimony, then that is not an overt act.
The court's statements yesterday speak for themselves. I'm not going to rehash that matter today. Anything else, Mr. J? Anything else, defense? All right, let's proceed with these objections. The court again has had the opportunity to review that fifth amended reciprocal discovery exhibit list filed by the defense, I believe back on October the 2nd or the 3rd, and the court was provided yesterday the actual exhibit list itself and the state's response and objections to same. There's no need to go over the items for which the state has no objections. So state, I would ask you just to provide as to the ones that you have objections for, and I have notes with regard to all of them. So you may proceed, sir.
One by one, I assume?
I think that's the easiest way to go. I know we start with item 1 and then go to 3, 4, et cetera. So we can ping pong it back and forth from there.
All right, regarding item number 1 on the fifth amended reciprocal discovery exhibit list from the defendant, I do not believe we have received those records.
Response from the defense.
Referring to 1, 1A is all the state's evidence that you believe you can use, and I labeled that as paragraph 0 in my response. So specifically talking about your paragraph that you labeled 1, certified medical records from Advent Health Orlando, paren, not yet received by the defense, paren, not yet received by the state, paren.
The defense is not receiving those records.
Motions or the objection is sustained. Moving to 3. Are these the 550 pages that we addressed yesterday?
My belief, and again, none of the exhibits are numbered as they get disclosed to the state. They're not Bates numbered. I do that myself. But what I have and what I believe is states 2 was 81 pages of records regarding treatment by.
I'm not talking about 2. You don't object to 2. Talk about 3.
Well, I do need to talk about 2 now because
Okay.
This morning, after having previously already been given 81 pages of records that purport to be from Winter Park Advent Health regarding treatment of Sarah Boone over a variety of different dates spanning 2018 to 2020. After having received those, reviewed those, and made my decision on not objecting, this morning I was given a thumb drive from the defense, which contained 119 JPEGs rather than a single PDF with 119 pages. A JPEG, for the record, is a digital picture. They were upside down, they were sideways. I got them all formatted. I was able to read them while we were waiting for Madam Court Reporter. They do not appear to be completely the same as what has been previously provided by the defendant in regards to Winter Park's Advent Health treatment of Ms. Boone. So I just want to be clear that now, since the state's response, there has been some sort of change in what those records purport to be, and we are objecting. We are requesting a Richardson hearing
Oh, wow.
119 JPEGs that we were provided this morning
Wow.
in regards to defendant's exhibit number 2.
At this point in time, the court is going to proceed with a Richardson hearing. Defense?
Referring to our paragraph 2.
Correct. My understanding, based on what Mr. J just provided, and based on his response, is that there were 81 pages provided to the state on or about September 27th, 2024. State had no objection to those. State further identified that this morning a thumb drive of 119 JPEGs evidencing something else was provided. And under the mandates of the 6th District Court of Appeal, based on Young v. State 369 Southern 3rd 1243, I am required to conduct a Richardson hearing. The court is conducting a Richardson hearing at this time.
81 pages.
The 81 pages are not at issue.
I understand that they will get care of it. We realize that they lack, that we have not sent them, so we provided those to the state as soon as we were there.
That sounds
And
a little
what do the
shady.
119 pages evidence?
Their medical records from, well, they can care of this over a period of time, that's going to be put down. Pending on her testimony. Not for her testimony, she suffered an injury and was fled.
I need more specifics than that.
Yeah, that sounds really shady. Really shady.
I don't have a time frame. I don't have when. I don't have what.
Well, it's going to have to be matched up with the dates that she was injured side.
But that all goes to the irrelevancy issue. We're conducting a Richardson hearing at this time. So I need to address the inadvertence or willfulness of the discovery. I need to address whether it was trivial or substantial. And if I don't know what's in these 119 pages, it's difficult for the court to determine whether or not this is a trivial or substantial matter. Are
Yeah.
these items that were previously produced in the 81 pages? Are they different? Are they different events? Are they different injuries? Are they different things? Moreover, I need to make a determination as to whether this violation had an impact on the ability for the state to properly prepare for trial. Those are the three prongs that I need to address.
Boy, this judge is so sick of this case already. My goodness. Yeah, George was in the suitcase for about 11 hours. I saw somebody a while ago talking, asking about that. He was in the suitcase about 11 hours.
But my understanding is those 81 pages were medical records and survey that we got from one of the previous lawyers that we had sent to the state. The other medical records were those that we had requested directly from the hospital that we got last week or late last week. They just failed to immediately provide those.
When did you receive them last week?
I'm not sure, Judge. I have to get my secretary.
Okay, I'm going to continue with the balance of the objections, and we'll circle back on the issue with regard to this objection.
Oh,
So
yes.
you can provide when, where, how, what.
Let's just
Understood.
circle back on this, Judge.
I'll make a note to circle back to this issue.
Yeah. Circle back.
Moving to number 3. Is this the Advent Health Winter Park Jorge not yet received by the defense? State's response reveals a motion in limine was filed regarding this motion. Is that the 550 pages that we addressed yesterday?
Yes, Your Honor, the state still has not received a whittled down exhibit that they plan to introduce at trial.
The court ruled on that yesterday regarding the blood alcohol content records, and the narrative would be admissible.
I'm still waiting for those particular pages to be disclosed.
Okay.
You want the exact pages?
Yes,
The DAC and the narrative law?
that's what's going to be offered into evidence at this point in time. Appreciate it.
I got staff.
So as with regard to the state's objection to item 3 that was previously ruled upon yesterday, is that the same with regard to the state's objection as to item number 5, certified medical records, Advent Health, Ultimate Springs, George?
I believe so, without being able to tell. Advent Health, it just seems to all come from Altamont Springs, the records. So I believe that is all encompassing, but so we don't have an objection other than the ones previously noted for 3 and 5.
Okay, thank you.
They were together
Moving
about
now
a year,
to item
year
number
and a
6,
half, 2
certified
years.
medical records, Orange County Jail, not yet received by the defense. I'm assuming they also have not yet been received by the state.
I think, did we address number 4? We went from 3 to 5?
Oh, I apologize. You're correct. 4, certified medical records, Advent Health, Altamont Springs, Sarah, not yet received by the defense. I'm assuming also then state you have not received them?
I believe the only records until this morning that I had was the 81 pages from Winter Park disclosed on September 27th, 2024. If there is something that they have from Advent Health, Altamont Springs, I don't believe I have that.
Defense?
Judge, we have not yet received those records. We have Seraphim medical records. And we have sent requests to various medical facilities asking for records.
The objection sustained. Moving to 6, certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they have not yet been received by the state either.
Last night, after business hours, I received 382 pages jail records regarding Boone. Once again, I had to spend my personal time reviewing these records.
That's not a good
Of
look.
the 382 pages, probably fewer than 5% refer to her mental health in the psychiatric treatment that gets provided to inmates at the Orange County Jail. The other 95+% of these records is all about physical treatment, COVID tests, things I won't outline here unnecessarily, since I do not believe these records will come in, but all of the things that you would expect a middle-aged inmate to have to go through for the course of 4 years. The state just is having great difficulty understanding what, if any, pages of these records are relevant. On page 135, there's records from part of her intake procedure on February 26th, 2020. On page 137, that's the initial screening when she came into the jail on February 25th, 2020. Page 137 and 138 include this initial intake screening. But from there, we get pretty far removed in time, pretty far removed in relevance. So the state is objecting to the introduction of these records. Even her intake screening on pages 135 through 138, I don't understand the relevancy of it. She indicates panic symptoms. She's semi-cooperative, has poor insight, unrealistic expectations, wants holistic treatment, doesn't like being housed alone. The screening on 225.
Let me interrupt here. So he's reading the like the initial intake and mental status and whatnot. Oh, every single thing that you're listening to is what you would write with for someone with histrionic PD. She doesn't like being housed alone. You know, really and truly, if you stop and give it some thought, the majority of us, if we were going into a jail, would your comfort, would you feel better being in a cell alone where you're protected, or in a bunk bed with a complete and total stranger? What would be your comfort level? I know without a doubt, hands down, I want to be in a cell alone with the doors locked so nobody can get to me and hurt me, right? I do not want to sleep in the room with strangers. So the fact that she doesn't want to be there in a room by herself, that she wants people with her, again, that is the pressure of the histrionic personality disorder, possibly, that she needs people. That if she does not see herself reflected in another, she almost like loses her existence. That is not the same thing as narcissism, y'all. It's very different.
Yes, type spirits, not wine. Last used 2/23/20, several times a week. The intake screening also includes a history of violence towards others. Yes. So there's no psychiatric treatment records for treatment for trauma. Any of the recognized trauma diagnoses in the DSM-5, PTSD, or any of the other trauma symptoms that can be diagnosed, there's no records of any treatment of that. It's just the anxiety, which, having read the expert depositions, I'm sure you understand that that was pre-existing.
And she's just been arrested. Her boyfriend is dead. She's just been arrested. That already is anxiety provoking. But here's something he did not say, and I think it should have been said. I think it's relevant. I have no doubt if she was drinking as the people described, if she was drunk by 9 a.m. every morning, there is absolutely no doubt if she was being questioned for 8-9 hours, she was going into alcohol withdrawals, which would have been characterized in the early stages by increased anxiety and anxious distress. I'm sure that when she went through alcohol withdrawal, she was very ill, and they were probably prescribing her medication so that she wouldn't, have seizures and such.
So our objection is we don't understand the relevance of these records. They do not go to her subjective state of mind on February 23rd, 2020. They do not go to help us understand whether somebody in her position was objectively reasonable on February 23rd, 2020. And quite frankly, most of it's just embarrassing and irrelevant. And it would bog the jury down, much like 487 pages of Jorge Torres's records. There's just a lot of COVID screenings and blood test results, and we struggle to see the relevance, Judge.
Thank you. Response?
Thank you, prosecution.
It's similar to the state about 10 days ago, sending me over 500 pages.
We addressed that yesterday. That's not germane to the issue.
As soon as I got another question, you mentioned anxiety was pre-existing. Well, that's not what your expert, Dr. Werner, in her definition. Anxiety she may be suffering from in jail from being in jail. So there were questions about that. But generally, you get these records that you know, and you have a forensic psychologist trying to evaluate patients.
What is the relevance of these records? What do COVID tests have to do with anything in this case? What do blood tests have?
He's not talking about COVID tests here, Judge, and you're off base on this. And I'm your friend, Judge. but to be fair, Owens, what he's talking about right here, he's actually correct.
To do with anything in this case? If they don't, then what of these 382 pages of records are relevant? What specifically is relevant? What page? What date? What document? You're not answering my question, counselor. They are listed on your exhibit list. The state is taking the position that these may be sought to be entered into evidence.
He has a licensed psychologist that did a full psych eval on her. Two of them, actually.
Of all three doctors predate their request for these records. So it's pretty unclear whether any of these experts have already reviewed these records. Now we're going to have to address, when do I get to depose
The experts
their
reviewed
doctor,
the
Dr.
records.
Harper? If she has not reviewed these records yet, when
She
do I get to
did.
depose her? Who's going to pay for the expedited cost for the transcripts? What relevance is it to her if she hasn't reviewed these records? They got these records post deposition, post evaluation. The last date that I believe she saw Ms. Boone was September 30th or October 1st, and we took her deposition 1st and 2nd. So this is also a problem, even if it's just going to be relied upon and not introduced. And I appreciate them letting us know that they don't seek to introduce these records into evidence, because of course, experts can rely on inadmissible evidence if within the course of that area of expertise, it's the type of evidence that is being relied upon. But how are these records relied upon if they acquired them after we've done all the depositions? Now, Dr. Harper did say that she relied upon some jail records during her deposition. State didn't have those at the time. I don't know what the date span
Oh,
is.
come on, prosecution. You've got access to the jail. Don't be silly.
To confront. We would like to know whether or not their experts have been provided these new records so that we can address that.
Mr. Owens? So she has not yet reviewed these yet, correct? Okay. Okay. State with. Okay. So state, understanding that tactical decision and that Dr. Harper is not reviewed and seemingly will not be relying upon these experts, does that cure any concerns that you have?
Yes.
All right.
Sarah looks irritated. Come on, calm yourself
Based
down.
on counsel's representation, the court's not going to sustain or overrule the objection, as the defense has identified they are not going to be seeking any of these 382 pages into evidence. Moving now to 8, 9, 10, and 11. There's no issue with regard to the body cam footage, but there is to the police report itself. What is your response to that, Mr. Owens?
The arrest reports are not listed as evidence in itself, but the reports may be used to refresh the officer's memory.
Okay. Does that cure that understanding? Okay. All right. So based on Mr. Owens' representation, as those items will not be sought to be moved into evidence or received into evidence, but only for the purposes of refreshing a recollection, the objection is not sustained nor overruled, as they're not going to be sought to be entered into evidence. Moving to Exhibit 17. No, I'm sorry, 16. 16 is a repeat of 11, so the court's going to adopt its, or similarly with regard to that exhibit. Mr. Owens, are you only going to be seeking the arrest report for the purposes of refreshing? Okay, so court same ruling with regard to Exhibit 16 as with 9, 10, and 11. Moving to 17, the jail calls involving defendant and third parties. State, anything else to add other than your written objection? Response? Okay, the objection is sustained. 18, prior criminal history of George Torres not yet received by the defense. Has the state received that?
Other than the arrest history that has resulted in interaction with the state attorney's office, we have not. He's not a testifying witness. So obviously, you have to provide, if they can't get it through due diligence, rap sheets of witnesses, but he's not a witness. So we have not done anything other than have a discussion about prior interactions with the state attorney's office.
Okay. Response, Mr. Owens.
Judge, we're referring to the prior record of long-term surgery.
Okay.
I know he had some priors in.
I'm just trying to understand, are they seeking to introduce some sort of paper, or is this just the broad notification that Ms. Boone, when she testifies, will be testifying about any prior incident of violence that she wants to regarding the decedent?
What is it? Is this oral testimony? Because this is an exhibit list, so that's my confusion.
She is so.
If it's oral testimony, that may be a different critter once the overt act is established under Holland.
She's going to testify to it.
So she's gonna take the stand. But of course she is, correct?
Okay, so there's not going to be any documentary or physical evidence that's provided, informations, charging affidavits, a criminal history report, anything tangible that's going to be offered to establish that criminal history other than Ms. Boone's testimony? Is that your position?
Yes, unless there's some dispute about that, we have to cooperate and ask to take some judicial notice that there was a case file that was set up.
Okay. Mr. J?
I don't know that papers generated by a government agency is relevant. Disposition of papers that were generated by some government agency is relevant. What's relevant is if there is an overt act that gets testified to, prior instances of violence by the decedent that she is aware of. That doesn't open the door to hearsay. That doesn't open the door to any of these things that he seems to be referring to, whether it's criminal rap sheets, which is what I believed he was referring to, or police reports, or state attorney records of no bills, or I don't know. Based on his last statement, I don't know what we're talking about now, but we do have hearsay objections to, I thought we were talking about physical exhibits, and that's what our objection would be to believing that what was represented was a criminal rap sheet.
Judge, part of that is about signal. Stealing that she has nowhere to turn. His family has nowhere to turn. The attorney brought three of the charges. At the time, she was sure that charges of violence against their family. Nevertheless, she wanted them. That's part of the syndrome. But in addition, in her mind, she felt like the state attorney had good time. Brought three of the cases where she felt helpless, that there was some outside agency that tied into her two minds whether or not she felt. So that may become relevant depending on what the heart says, on whether it's not that, about the brain says, as to whether or not she felt helpless because the state attorney's office was not.
But that all sounds like oral testimony. And again, this goes back to this is an exhibit list. What are the exhibits? Tangible, physical. Okay. What does that have to do with prior criminal history? Because that's the topic here. Prior criminal history of George Torres Jr. not yet received by the defense. That's the line item in your exhibit list. Okay. All right. So based on counsel's representation of the withdrawal, the court will not sustain or grant the objection. Does that clarify that for you, Mr. J?
Thank you.
All right. Moving now to 19, Orange County Sheriff's Office investigative workup report. Response. Okay. With that understanding, Mr. J?
Yes, I'm not clear what a workup report is, but it's not sought to be introduced into evidence, then I will accept that.
Okay, so accepted. Your objections overruled based on counsel's representation. The investigative report workup will not be offered into evidence, but merely for refreshing. Moving to 21, all court orders in all Orange County criminal cases regarding George Torres. State. Any further argument?
I believe we went from 19 to 21 without addressing 20.
Oh, I apologize. I had the wrong, I color-coded this and I miscolor-coded this one. Okay, then based on counsel's representation of withdrawing that, the court will not rule on that objection. Moving to 21, anything further, because it's we kind of addressed this as well with number 19. Anything further, argument state. Anything further, argument? Okay, I'm going to overrule the objection as to, as this point in time, because if a declination of prosecution may have been filed, that may be relevant based on Ms. Boone's testimony. So I'm going to overrule your objection at this time, assuming the overt act concept is placed into evidence. Moving to 22, family law case file Boone v. Boone, case number 2017 DR 01660-O. I understand the state's objection as to relevance and hearsay. Response? What does the non-payment of alimony have to do with what's happening in a family case?
Well, that goes to we're in a position that she's in now. He's biased. To show that he's biased, that he has not been helpful. That shows bias.
Response?
Sounds like this is ongoing pending litigation that has not been decided by a circuit court judge in 1960s. I can certainly understand why one may believe they don't need to pay alimony when their spouse is incarcerated. I can certainly understand why somebody may believe they don't need to pay child support when their spouse is incarcerated, and they would probably want to seek legal redress about those issues. It sounds like it's all ongoing.
Are there any orders from the court in that case addressing the non-payment of alimony and that being contemptuous or in violation of any court order?
No, they were divorced. I think there was a marital settlement agreement that was attached to the final order. Brian Boone did open the case back up to move the child to Gainesville, which has happened. And then my understanding is there's still some issues. I think she was given some kind of a notice of a hearing coming up. She's not represented. I don't represent her.
Is there, so if there's no order in the court file finding there's a violation of an order to pay alimony, what is?
Well, there's a final order about his obligation to pay alimony, and I think if he gets on the stand, I'm going to ask him, but you haven't paid her alimony like you were ordered to do so. I can go into on the cross-examination.
But it sounds like there's pending litigation, including a relocation and I don't know. It's not my case. I haven't looked at it.
That's been decided. He has been able to relocate. I don't know all the ramifications. I'll look at the court file. I think we had subpoenaed the custodian of the records of the court file. I'll look at it and I'll let the court know and the state know.
Can you all approach this for a moment?
Oh, my goodness. This is going to be fireworks. Oh, look at that look. She makes me laugh. I don't know why, because she's so ridiculous. Let them eat cake. Isn't that right, old Sarah? Princess Sarah. Oh, they're having a little girl time. That's cute. Sarah is, I'm telling you, Sarah is loving this. She has never been so fulfilled. She has so many girlfriends. She lives in a dormitory, just like college students do. She gets snacks. She is having a great time, y'all. This is this is one of the best things that's ever happened to Sarah Boone. Oh, yeah, I agree. Fractured fairy tales. When this thing gets real, when the witnesses are up on the stand and the tears are flowing and the trauma is showing, that it's not going to be girl time anymore. You know what I mean? We'll see the real Sarah Boone come out, and she is not a pleasant woman. Yeah, Sarah Boone is actually a historical figure. Yes, Critter or Critters Watcher. Um, she was born a slave who became a dressmaker and then inventor and patented an ironing board. Yeah. Oh, sure, she'll
I
appeal.
thank you all both for your arguments and clarifications. Based on the court's going to overrule the objection at this time for the reasons discussed at sidebar. Moving now to 23, the policies and procedures of the Orange County Sheriff's Office regarding Miranda. Have those been received by you, Mr. Owens?
Yes, sir.
Okay.
I'm no longer seeking to introduce those.
Okay. All right. Based on counsel's representation, court takes no action on the state's objection.
Same with 24.
Based on that representation, court takes no action. Moving to 25,
All
reference
right.
to Tealwood Park Apartments.
This is what I like. Moving along.
Received what we wanted. We're not seeking to introduce that.
Okay. Based on counsel's representation of not seeking to utilize it, court takes no action on that objection. Moving to 27.
26, the defense does not intend to introduce any of the 911 calls.
Okay. All right. Thank you.
Thank
Moving
you,
to
Mr.
27,
Owen.
the video footage of the arrest on February 25, 2020.
The defense has not received that. The state may have it in their possession. It appears there's news footage of Sarah Boone in handcuffs being escorted.
Well, yeah, we've all seen it.
State, you have such an item in your possession? News footage?
I have it.
No? Not that I know of.
It's
We
when
have
they're
not received
walking
it,
her
sir.
to the Suburban.
Okay. All right. Based on it not being received, court's going to sustain the objection. Moving to 29, the iPhone photo file name. Not going to read it. It's very long.
Judge, I do not intend to introduce 29.
Okay. And court takes no action based on counsel's representation. Moving to 32, iPhone photo. Yeah, I'm sorry, sir.
29, what is?
There is none, as the defense has advised they are not seeking to enter it into evidence. 32, another iPhone photo file name. It's very long, so I'm not going to read it.
Defense does not intend to introduce.
As such, the court will not take any action on that objection. 33, another iPhone photo file name. Court's not going to read it because it is too long.
Defense does not intend to introduce.
Based on counsel's representation, court takes no action on the objection. Moving to 48, another iPhone photo file name, 505 period JPG underscore embedded underscore 1 underscore 772.
We would stipulate.
All right, the objection is sustained based on stipulation. Moving to 59 and 60. I understand your objection, state. Any response?
Can somebody explain to me what the hell is Sarah doing? She's looking at his papers. She's putting little check marks on her papers. She's picking up random papers as if she's reading or looking for something important. Is she just in a delusional state? Has she convinced herself that she has very important work to do alongside, Mr. Owens, and she's the assistant attorney? This is so reminiscent of Jodi Arias that it's kind of scary.
Any and all exhibits previously listed by the state?
She's house captain.
Yes, sir.
Judge, Mr. J is a smart lawyer. A lot of experience. He's board certified. He's filed this motion in limine to disallow the battered spouse syndrome twice. And yesterday, we were forced to disclose the overt act that constituted our defense that tied in with the self-defense. And so Practically, he was able to get us to that posture, so he knows our defense and how we're coming at it. The problem is the state has not been forced to give the details of what they allege Sarah Boone's overt acts or non-acts.
I need to clarify something. There was no forcing yesterday. The court reviewed Dr. Harper's deposition, and there was no overt act that she had testified to. She was specifically inquired about any imminent fear, and there was no response to those questions. The word overt act did not appear in any of the 4 or 5 sessions that she had with Ms. Boone. And the state was seeking, as we addressed yesterday in limine, to prohibit that.
I disagree with that. That was his deposition. He tried to control the witness. He kept cutting her off. He wouldn't let her finish explaining. I certainly wasn't going to do it. She's going to testify in trial about it. It's not my fault that he felt like he got the answer he wanted and he moved on. He didn't ask for any elaboration about that. But that's going to come out. But I understand that's all you had. But we had to do that. The state has not had to do that. And I understand under the Sixth Amendment that we have a right, the accused has a right to be informed of the nature and cause of the accusation. And the problem with that boilerplate information is we don't know what they're claiming that she actually did, overt act or omission, that constituted second-degree murder. So because of that, we have to list everything because we don't know. It's like he wants to know. He wants the court to make rulings so that he can tweak his opening statement based on the court. The same with us. We don't know how to respond to their opening until they give it because we don't understand the full nature of what they're alleging Sarah Boone did to constitute second-degree murder. So in an abundance of caution, we've got to list everything that may be relevant, but we don't know yet because we haven't heard. I would like to renew, they've renewed their motion on battered spouse. I would like to renew my motion for a statement of particulars so that I could know, the defense team could know what it is exactly that the state attorney is alleging that Sarah did or did not do that constitutes second-degree murder. It's a serious charge. This is not, it's a unique case. It's not something that happens every day.
It's not so unique,
that it
sir.
was proper under that rule of a statement of particulars so that we could be informed about what it is exactly that they claim that she did criminal so that we could prepare a defense. And it goes directly to this point, which is they want to know why we want these documents and what documents specifically are y'all going to use. Well, it's difficult to tell when we don't know what we're accused of.
Any response, Mr. J?
Okay, can I say something? Okay, isn't this a lot like drunk driving? Wouldn't you say that that is a reasonable analogy? Sure, it's not often that you hear, hey, she done him in with a suitcase. That is not something that we very often hear. But the reality is she was drunk. She put him into a dangerous situation with no ability to predict the lethality of what she was doing. And then his oxygen was restricted. He couldn't completely breathe in because of how his body was folded, and he suffocated. It's exactly like drunk driving. You get drunk, you get in your car, you have no way of knowing the outcome, but your drunkenness is creating poor judgment, slow reaction time, the possibility of falling asleep at the wheel. And if you happen to fall asleep while you're drunk driving your car and you hit someone and kill them, it's vehicular homicide. This is not a unique case. The only thing unique about it is that it's a suitcase rather than someone drunk with a gun or someone drunk driving. That's my thoughts. What do you guys think? Sarah obnoxiously talked the entire time the judge was giving his instructions to the jury. She shows no respect for the solemn duty set before the jury. Terrible first impression. Oh, she's so out of touch. There's Critter Watcher had a flashback of watching Daryl Brooks shuffle through all his papers. There's another one for you, Daryl Brooks, man, but he was kind of just really mentally ill. He had like some chemical stuff happening with him. Owens is going to run out of spaghetti to throw at the wall. The judge is about to lose his patience. Totally agree, DB. This judge, this prosecutor, they are over the Sarah Boone team. How many times can the judge request for Owens to be specific and then simply be ignored? I completely agree.
Yes, sir. Mr. Owens, Mr. Cacciatore, myself, and Dr. Werner all sat together within 5 feet of Sarah Boone the first week of October and heard the final version. It's not very dissimilar from the version of Dr. Harper, but Dr. Werner's deposition was provided to the court previously for our motion to eliminate. I don't understand the position they're taking that they were forced to show their cards when Dave Cacciatore and myself and Mr. Owens and Dr. Werner were all there together to hear her version. And her version is, it was all fun and games. It was Sunday fun day. He gets into the suitcase. We're all laughing. I zip it shut. We're still laughing. There comes a point in time when he says, I can't breathe. This triggers her based on her past abuse, no overt act that day. And she begins violently doing the things to the suitcase that she says she did, whacking him with the baseball bat on his fingers. And now, after being the initial aggressor, now after having committed a forcible felony or two, now after having put Mr. Torres in a reasonable fear of death or great bodily harm, she says, well, she realizes now if he gets out after these things that I've done to him, I'm in big trouble. And it's my understanding that we have had this discussion and that if that is the proffered testimony, that is not going to amount to an overt act, which will allow for reputation evidence, past incidents of violence, or the battered spouse syndrome evidence. They weren't forced to show their hand. I was there. The rules of criminal procedure allowed me and Mr. Cacciatore to be there and to witness this evaluation. So that being said, we're not abusing the system. We're not doing anything that we're not allowed to do. And we're making every effort to make sure that we understand how this trial is going to go down and how they, and Ms. Boone understands how the trial is going to go down. Because my understanding of how it's going to go down is she's going to have to testify to the specific events of that day. And right up when she comes to the point to saying, and when he said, I can't breathe, the state attorney, Mr. J, is going to object. He's going to ask to approach. He's going to say, Judge, there's been no change in her testimony, unless there is, then that's a whole different bag of worms. But if there's been no change in her testimony, Judge, we got a ruling prior to this that there's been no overt act testified to. Now we're going to object to her answer of because of the past violence, and we're going to object to any further attempt to bring in prior violence, reputation evidence, or battered spouse evidence. I just want everybody to be clear and on the same page about that. Now, in regards to their request, a renewed request for a statement of particulars, they've had the discovery for several years. This is the state's case. A video that starts at 11:12:45 p.m. on 2/23/2020. Sarah, for everything you've done to me. Sarah, for everything you've done to me. Sarah, F you, laughter. Sarah, F you, laughter. Sarah, stupid. Sarah, that's my name. Don't wear it out. Sarah, I can't effing breathe, baby, seriously. Yeah, that's what you do when you choke me. Sarah, 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 laughter.
Oh my
Sarah,
God.
I can't breathe, babe. Laughter. That's on you. Sarah, I can't breathe. Laughter. That's on you.
Wow.
Sarah, unintelligible, drunken, slurred words. Laughter. Sarah, 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 I can't breathe, baby.
Ah.
That's what I feel like when you cheat on me. Sarah, F you. I can't effing breathe, Sarah. You should probably shut the F up. Sarah. Shh.
Wow.
That's our case.
That is
an advanced,
brutal.
depraved mind, conscious disregard for whether he lives or dies, whether she put him in there or not. She let him remain for 2 minutes during that video. And then at 11:23:03
That
p.m.,
was
there's another 22-second video.
to have it presented like that, you can, that was brutal. That was brutal.
And it just zooms in on the suitcase.
There's no coming back from that, Sarah. Your goose is cooked.
Sarah. So that is a second-degree murder case when the medical examiner comes in and says, George Torres died from positional asphyxiation and the asphyxiation from being in a confined space. And eventually, after Lord knows how many breaths, he expired in that suitcase when she went upstairs and went to bed. But in addition to those statements, we now have her new statements, which are she intentionally violently shook the suitcase, threw it upside down, hit him with a bat, committed independent forcible felonies. And that's going to be corroborated by the medical examiner's testimony to all the blunt force trauma to both sides of his face and his mouth.
God.
That's a second-degree murder case. That is what we're going to be presenting. This is a portion of what I will be telling the jury this afternoon.
Oh my goodness.
Rebuttal.
I wanted that in writing weeks ago.
Oh my, you know what? You got it in writing and audio because Sarah, your client, recorded it, sir. Wow, this is terrible.
She was assessed, Sarah Boone, the defendant, was assessed at the Orange County Jail a couple of weeks ago by Dr. Warner. Their rebuttal, state's expert. The characterization that Mr. J just gave about her testimony, I do not agree with.
Okay. All he did was read her
Dr.
text.
Warner, 5 of us there. Dr. Warner, Sarah Boone, myself, and the 2 prosecutors. The mistake we made was not recording that assessment.
Yeah, that was a big mistake, sir.
Because I can't testify to what she said. The 2 prosecutors can't testify to what she said. The only 2 people that can testify to what she said is Dr. Warner and Sarah Boone. We dispute their characterization of what she said.
It's recorded, James.
Sarah Boone and the doctor. And jury, while we're here, they are going to have to decide who to believe and what happened. But that is a jury question that we're all going to have to wait for.
Well, we know what the jury's
I
going to say,
appreciate the
buddy.
prosecutor giving me the evidence he intended to introduce. Prove that something I was asking for a couple of weeks ago.
But that was
For the same reasons
recording.
that the court
verbatim.
identified when we had the hearing on the original motion for particulars, the court relies on its same ruling in the case law identified at that time. The renewed or tennis motion for statement of particulars is denied. The state's objections as to paragraphs 59 and 60 are also overruled. The only other issue to address then is the Richardson violation. Court's going to take a short recess, and we'll address that as promptly as possible. It is 5 till 11. I still intend on moving forward with jury selection this morning. We will be moving to 23, correct?
Yes, sir. I'm just making sure I'm clear on 60. Our request was that prior to the testimony of any of the listed witnesses, which I listed only by initials, that we have the opportunity to depose them and we address the cost of expedited transcripts. I just want to make sure they meant to overrule that.
I apologize because I was just looking at what was articulated in the exhibit list, which was any and all relevant reciprocal discovery to be obtained through ongoing investigative efforts. What's your response, Mr. Owens, with regard to these persons identified in the state's objections who may be called and deposing them?
Well, the state listed a bunch of witnesses on October 3rd. Well, the court allows the state to do this and take the depositions, then we ought to be allowed to take the depositions.
I believe those are the same witnesses that they've listed in regards to the prior incidents. The deputies that went out on the call outs and the cases that resulted in cases in the state attorney's office. 911 dispatch.
Okay. Is that accurate, Mr. Owens? That October 3 state's list?
Again, we don't dispute that they should be allowed to depose them, but they've been listed by both parties, whereas these people are unilaterally listed by the defendant.
Judge, again, I'm not complaining. Been on the case 45 days as we have gotten witnesses or found witnesses, Billy Lane or whoever else was trying to locate them on my team. We have provided support. Based on what Sarah Boone has asked us, this witness, we've made attempts to comply with her request. Whether or not we're going to call them, the law says, the case law says, you know, Sarah Boone has a right to trial, Sarah Boone has a right to testify, Sarah Boone has a right to appeal. I believe those are fundamentals. But the defense lawyer makes the decision about which witness to call. So although she may want some witnesses, she's asked us to find them and list them and locate them, which we've done. That doesn't mean that I have to call them, and it may not She may not call many of those that she wants to, but I believe my right to do that and present our defense with our witnesses is paramount. She doesn't have that right.
Okay, thank you. All right, court's going to take a brief recess to address this and the Richardson violations. We'll be in a short recess. Thank you.
Oh, Sarah didn't like that, did she? She's mad. Look at her. She's like, I hate James Owens. I hate him. He's stupid head. Oh, look. Oh, man. She's pouting big. Gotta stay tighter than that, Sarah. I got a feeling this is going to get real uncomfortable for you before it's all over with, girl. That's the name. Don't wear it out. Oh, this girl. Man. Would you want to be her roommate in the dorm? DB, do you want to be her roommate at college? That really got under her skin. She didn't like that at all. Sorry, Sarah. James is the boss, not you. Bum, 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 bum. The Honorable Ms. Sarah Boone. Dun, 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 dun. Oh, she's
All right, we're back on the
really
record. Case
tore
number
up.
2020 CF 2603, State of Florida versus Sarah Boone. State appearances for the record.
William J.
Defense.
So James Owens for Sarah Boone.
Ms. Boone is seated at council table wearing the same clothing from earlier this morning. All right, it is 11:24. With regard to the Richardson hearing, with regard to item 6, the defendant's fifth amended reciprocal discovery list, the court is going to reserve and have that hearing tomorrow morning at 9 a.m. Defense is to provide an edited version of only the records that pertain to anxiety or their lack of that thereof to the state before 9 a.m. tomorrow morning.
Judge, number 6.
Okay. Did that happen when I was not here?
No, it happened earlier while we were here.
And what specifically was the Richardson violation for then, if it wasn't for number 6? And I apologize.
Number 2 is the 119 new JPEG pages, according to be from Winter Park Advent Health, and they're a little bit different than the one pages I previously received.
Okay. So the ruling remains the same. Court's going to reserve, address the Richardson hearing tomorrow, and you were to provide an edited version of those records that you seek to offer into evidence. Mr. Owens, before 9 a.m. tomorrow morning.
Regarding the paragraph number 2, regarding the Winter Park Advent Health records, the 119 that we gave him this morning.
That is correct, sir. With regard to the witnesses that have been identified by the defense in paragraph 60 of the state's response, those witnesses will be excluded if not deposed prior to being called as witnesses, and the defense shall pay for any and all expedited transcripts.
All right, Judge, the same as should apply to them. There were 3 people that they gave us late that we didn't have before: Rachel Fenner, Meredith McCaskill, and Victoria Shelton.
Okay, response?
Meredith McCaskill is an FDLE analyst that is substituting for an analyst that is unavailable during the trial period. So in an effort to not continue the case, got a substitute analyst. So that's our reason for the late disclosure on her and the other 2.
Michelle Fenner and Victoria Shelton.
And those are the 911 dispatchers. If we end up having to call them, then that's fine. We will pay for expedited transcripts. What I would expect not be likely more expensive.
Okay. Has the FDLE analyst that was originally set to testify been deposed in this matter?
The Richardson violation, that's just to find out if the rules of discovery have been violated. And if so, what would be the proper remedy?
Statutory did not believe that the defendant ever proposed that.
Okay. Any other positions, Mr. Owens? Okay. All right. State will afford the same opportunity to the defense as provided by the state to the defense. Court's going to be in recess. It's 11:27. Hang on. Juror number. Yes. Let me address that. Can I have that? please. If you also have yesterday's sheets from jury selection, Madam Clerk has advised that jury services has told us the juror in seat 25 wearing badge 63 called. The nephew that she cares for is ill and that she is not here due to caring for that child. He is not here due to caring for that child. State's response, if any. So stipulated, juror number 25 wearing badge 63 will be struck for cause. We'll advise the jury services to call them and tell them they do not need to report. With regard to the order tennis motion as to Ms. Boone's request for snacks, the order tennis motion is denied. Ms. Boone is being provided all the same services as to any other inmate being transported for the purposes for trial. Anything else we need to address, State, before we report back to 23 at 1 p.m.? Defense?
No, sir.
All right, we'll see you all at 1 p.m. Thank you very much. Court's off the record. All at 1 p.m. Thank you very much. Court's off the record.
Denied. Denied. Snack time.